All right, good afternoon, everyone. I call to order this special meeting executive session of the Scottsdale Unified School District Governing Board. The date is Tuesday, January 30th, 2018. The time is 4:05, and we will start with a roll call from my far right.
Sandy Kravitz.
Allison Beckham.
Pam Kirby. Kim Hartman.
Barbara Perleberg. All board members are present, and we do have a quorum. And a cell phone. Is that right?
Do a pledge in every public meeting.
I just noticed that that is not on here, but we will.
Let's
Please
do it.
stand for the pledge.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Right. We'll move directly into our first agenda item, agenda item 2, acceptance of resignation of Laura T. Smith. Dr. Birdwell, would you like to start us off on this personnel issue?
Yes, Governing Board, we received a letter from Laura Smith requesting immediate resignation, and so that we are asking this afternoon that we accept that resignation at her request.
Okay. Are there any questions or comments at this time? All right. Would someone like to make a motion?
I'll make a motion for Laura.
I can make a motion. I will make a motion that the governing board accept the resignation of Laura T. Smith.
I'll second.
Thank you, Board Member Hartman. All in favor?
Aye.
Aye. Motion passes 5-0. We will move on to our next agenda item, 3A. We will vote to convene an executive session for discussion and consultation for legal advice with the attorneys or attorneys for the public body pursuant to ARS Section 38-431.03A3 concerning 1, Arizona conflict of interest law and state law requirements and district policies and practices in connection with the conflict of interest of district staff and in compliance with the conflict of interest law by district staff, and 2, procedures for release of information pertaining to conduct of district employee. Also, agenda item 3B, discussion or consultation with the attorneys of the board pursuant to ARS Section 38-431.03A4 in order to consider its position and instruct its attorneys regarding the public body's position regarding the professional group Public Consulting, Inc. Do I have a motion to convene an executive session?
So moved.
Thank you, Board Member Kravitz. Do I have a second?
Second.
Thank you, Board Member Beckham. All in favor?
Aye.
Aye. Motion passes 5-0. We will convene executive session. Good, all right.
6:51, it looks like 6:51.
Good evening. Governing Board is now reconvened in our special meeting. The time is 6:51. We'll do just a quick roll call from my far right.
Sandy Kravitz.
Allison Beckham.
Pam Kirby. Kim Hartman.
Barbara Perleberg, all board members are present. We will move to agenda item 5, and I will make a motion to waive the attorney-client privilege of the district, except to any legal advice from Ms. Siegel as to future legal action the district may take. I further move to waive the attorney-client privilege as to any final report Ms. Siegel regarding the conflict of interest investigation. Finally, I move that Ms. Siegel give the verbal summary that she provided today to the Attorney General in writing. Do I have a second?
Second.
Thank you, Board Member Hartman. All in favor?
Aye.
Aye. Motion passes 5-0. Ms. Siegel.
Morning, I'm sorry, it feels like morning. Good evening, Governing Board. I'm Susan Siegel. I'm a partner at Gus Rosenfeld. I was retained by the District General Counsel to do an investigation on two aspects, one of which is the conflict of interest of Laura Smith, who is now a former employee of the district. I want to point out that I was asked to do this, I believe, because of my background in procurement, business practices. I'm a former school administrator, legal counsel like Miss Marshall, and I helped, was one of three people who wrote the Arizona Procurement Code. And finally, I served for, I believe, 7 years, under Terry Goddard as general counsel in public advocacy, and am familiar with the conflict of interest laws and the appropriate disclosures that must be made pursuant to the law. I have not finalized a formal report. I'm going to give a verbal summary of the highlights of my findings, and then I will prepare, as you directed in your motion, my summary and give it to the Office of the Attorney General, and I will finish my report within the next 5 days, which will then be delivered. All right, here we go. Laura Smith began working as the CFO of the district on February 15th, 2017. At the time, Ms. Smith was at the time she began working as the CFO, Ms. Smith was a shareholder, director, and president of what we call PGPC. It stands for Professional Group Public Consulting, Inc. So I will be using PGPC throughout this verbal summary. In her interview that I conducted, an interview of Ms. Smith on January 19th, 2018, Ms. Smith said she could not remember the exact percentage of ownership in PGC as of May 31st, 2017, but she estimated it to be 15 to 20%. That is important because the conflict of interest law says that you do not have a substantial interest if you own less than 3%. A copy of a tax filing that she later gave me at my request after the interview shows that her interest in PGPC in 2016, the year before, was 17.72%. You may ask why I focused on May 31st, 2017. The reason is that Ms. Smith stated in her interview that she notified PGPC that she wanted to sell her interest in PGPC back to the company on May 1st, 2017, and that the sale occurred on May 31st, 2017. Although she provided evidence subsequently that she notified the company that she wanted to sell her stock, she has not provided evidence that the stock was actually sold or how much of her stock was sold, even though I have asked her on several occasions, and I've asked Caroline Brackley, who is the managing director of that company. Caroline Brackley is the sister of Laura Smith. Throughout Ms. Smith's employment as CFO, Ms. Brackley was and still is listed in the records of the Arizona Corporation Commission as a director, officer, and principal shareholder of PGPC. Although I have asked, Ms. Smith has not provided information about the percentage of ownership Ms. Brackley holds. There are two other shareholders in PGPC. One is a woman named Rosa Sines, and another is a gentleman named David Wood. I do not know their percentages, and I have not verified whether Ms. Brackley owns over 3%. That would be important to determine if she did indeed have a substantial interest. I suspect, given the fact that there were only 4 shareholders, that Ms. Brackley owns over 3%. I want to also add that the records of the Corporation Commission show, even today, that Ms. Smith is still a director, officer, and principal shareholder of PGBC. At the time, Ms. Smith signed a conflict of interest disclosure on February 24th, 2017, that does not comply with the letter of the law because it does not fully disclose her substantial interest in any transaction between the district and PGPC or in any decision of the district relating to that interest. It is also deficient because it did not fully disclose the substantial interest of her sister, Caroline Brackley, in any transaction between the district and PGPC, or in any decision of the district relating to that interest. I want to add that the conflict of interest law not only applies to the employee, but it also applies in the event any relative, as defined in ARS Section 38502, has an interest in any transaction or decision. And it lists as a relative sister, and Ms. Brackley is a sister. Also, on the conflict of interest form that she signed, it also asks her to disclose the interest of a close relative. The conflict of interest disclosure that the district uses is contained in your policy manual. It is identical to the template conflict of interest form that the Arizona School Boards Association uses. It's a template that, for instance, Paradise Valley, Chandler, other large school districts use. I did a search. I did not search every 250-some school districts in Arizona, but I did pick some that are approximately the size of this district. It's also a conflict of interest form that you inherited, that the districts had for a number of years. I cannot put my finger on when it was first adopted, but it has been in those books for a number of years, from what I understand. In May of 2017, Ms. Smith signed another conflict of interest form. In that, she failed to disclose the substantial interest of her sister, Caroline Brackley, in any transaction between the district and PGPC, or in any decision of the district relating to that interest. In my opinion, for that reason, that disclosure was also inadequate and did not meet the letter of the law. Neither the district general counsel nor the district superintendent knew that Ms. Brackley was Ms. Smith's sister, and in fact, employees in the office say that many employees that I interviewed said they did not know. The ultimate decision to hire PGPC to conduct the procurement and award of the CMAR, which is Construction Manager at Risk, RFPs, was made by Mr. Danny O'Brien, and it was made due to the fact that after the retirement of the district director of procurement, no one in the purchasing department had experience in procuring CMARs, Construction Manager at Risk, RFPs. Employees in the district purchasing office and Ms. Smith's secretary, now Ms. Smith's former secretary, because she doesn't work here, say that Ms. Smith told them that she had a conflict of interest and could not do anything in connection with PGPC. However, in all, Ms. Smith signed off on 5 change order requests that increased the amounts of underlying purchase orders to PGPC. She signed off on an additional one that closed a purchase order that had no dollar value. All of these were in connection with consulting services for the CMAR RFPs. The total of those 5 change orders comes to $16,072.40. There were other change orders that were signed, other change orders for POs to PGPC that were signed by other employees. I found some signed by Mr. Hartwell and some signed by Mr. Witten, who is in the business office. It is noteworthy that in my interview of Ms. Smith on the 19th of January, Ms. Smith was shown purchase orders at that time totaling $8,000. An expert, let me back up again. I am an attorney, but I'm not an accountant. I'm familiar with a lot of business practices and the USFR, but I am not a school district accountant. So I reached out and obtained the services of an expert witness who's a former CFO of Mesa Unified School District, to have him review these purchase orders and have him review these processes. His opinion, which he has rendered, was that it was inappropriate for Ms. Smith to sign these change orders without knowing who they are being issued to, and she should not have signed any change order without knowing which vendor was the subject of the purchase order and the change order. In her interview, Ms. Smith said that she inadvertently signed these change orders because it did not provide the name of the vendor up in the top form. These are district created, long ago, change orders. And they have a box up there that show the name of, or where the name of the vendor should be. The ones that she signed did not have the name of the PGPC entity. However, again, as the expert witness says, you should know before you sign these who they are being signed for and who the vendor is. The COs are generally, the change orders are generally handled in the business office. They are not in, and the expert says, this is a function of the business office. In a large school district, it rarely, if ever, goes to the superintendent's office. So usually there's no way that the administration would know unless somebody called it to their attention. In addition to those, 5 POs that increase the amount of purchase, 5 change orders that increase the amount of purchase orders, there were 6 purchase orders to PGPC that were approved by Ms. Smith. Now, I want to add, these are not ones with her actual signature. These are ones that are computer generated, and they print L.T. Smith. There are others that say, for instance, B. Witten for L.T. Smith, or S. Crozier for L.T. Smith. I interviewed both Ms. Crozier, and Mr. Witten, who both said those are instances where they were told, or they knew that PGPC was an entity that Ms. Smith had a conflict with, and so they approved those. But they also said they wouldn't know about those and said, unless somebody called them to their attention. So the amount of the 6 POs to PGPC was a totaled $43,766.35. In my opinion, my legal opinion, Ms. Smith's actions violate ARS Section 38503 and Board Policy GBEAA, in that A, she did not fully disclose her substantial interest in the February 24th disclosure. B, she never fully disclose the substantial interest of her sister, Caroline Brackley, in any transaction. And C, she did not refrain from participating in any manner in such transactions or decisions because she approved POs to PGPC, she signed purchase change order requests, and she participated in finding out the cost of PGPC to consult on the CMAR procurement. I want to tell the district that all open POs with PGPC have now been closed at the direction of Dr. Birdwell on January 24th, 2018. Ms. Smith was told on several occasions by Dr. Birdwell that she should take herself out of all authorizations and decisions pertaining to PGPC. She assured Dr. Birdwell that she was doing just that. Documents reviewed in this investigation have been forwarded to the Office of the Arizona Attorney General, and I will continue to forward that office any documents that I uncover and discover. I'm open for questions.
All right. Board Member Kirby.
Thank you for your report, Ms. Siegel. Just question, did district personnel cooperate with you in all regards, document requests, interview requests, et cetera, in this particular investigation?
They did, except that Ms. Smith would not let me record her statement, so we took notes. But they were fully cooperative. They were always made themselves available. They shuttled between the business office on Main over here so I could interview them in order. They were very cooperative and gave me some insight on how business is conducted.
Thank you.
Any additional questions or comments?
I want to add one other thing. I verified with each employee before they gave a statement or were interviewed that they were voluntarily appearing there and that nobody was making them come there. I verified that also with Ms. Smith.
Any additional, Ms. Marshall, I'm sorry.
Ms. Siegel, did you want to share with us when we can expect a final report?
Oh, yes, I'm sorry. I expect to have the final report in the next 5 days, if not sooner. If it slowed down a little bit, and we had promised the public and you that you would have a report within a month after I gave the last report on December 19th, and now it's, January 30th. So I apologize for the delay, but we've been working really hard to get the information in the interviews and understand really what was going on with those purchase orders and change orders.
Thank you.
All right, well, I will, no further questions or comments? I'll just thank you on behalf of the board for this very thorough investigation. Thank you for bringing clarity and accuracy to this situation. We very much appreciate it, and all your hard work and all the hard work of our staff.
Thank you.
Thank you. Thank you. Okay, do I have a motion to adjourn our meeting this evening? So moved. Thank you, Board Member Kirby. A second? Second. Thank you, Board Member Beckham. All in favor?
Aye.
Aye. Motion passes 5-0.